So, dear friends of ECTA, dear delegates, it's a pleasure to see you all here after a wonderful lunch. I hope you will enjoy this session as well. I have the pleasure to continue the session we had in Budapest under the chair of Mireia Kurei, our past president of ECTA. But in Budapest a year ago, we didn't know too much about all these things we do know about today. I have the pleasure of having here on my side Christina Bercial-Chaumier, Tanya Clark, and Debbie Brinkat. We will start with Christina looking at the latest development from an EU 27 point of view and also from an ECTA point of view. Then we'll continue with Tanya Clark looking at the Brexit developments basically from a UK point of view. And finally, Debbie Brinkat from Procter & Gamble looking at the whole development and the situation from a corporate perspective. So I'll start with Christina. Christina is chair of the ECTA Law Committee. She's attorney at law and managing partner of the Alicante office of Casalonga in Spain. And now she's also a council member since yesterday of ECTA. Congratulations. So, Christina, the floor is yours, please.
Ladies and gentlemen, dear colleagues, dear friends, first of all, thank you to ECTA for inviting me to participate to speak in this interesting and hot topic and to present ECTA position on the last withdrawal agreement. Following to the United Kingdom notification of its intention to withdraw from the Union pursuant to Article 50 of the Treaty of the European Union, and unless a withdrawal agreement establishes another date or that such period is extended by the European Council, all Union primary and secondary law will cease to apply to the UK from March 30, 2019. So at midnight, the withdrawal date, the United Kingdom will become a third country. However, pursuant to Article 121 of the draft withdrawal agreement, a transition period ending on December 31st, 2020 is foreseen, but Tanya will speak about that later. So, what do we have? I have divided my presentation on two parts. The first one is Brexit and users associations, what the users associations have been doing since the Brexit referendum was made. And the second part will concern all the official notice issued by the Commission and the EU IPO. So the first part will consist on a little explanation of the meeting that the users associations had with the European Commission on June 13, 2017, and also on the joint statement that was drafted with a number of users associations concerning the exit of the UK and in questions particularly in relation to trademarks and designs. And this joint statement was sent to the Commission on March 23, 2018. The second part will concern all the official documents and position papers issued by the Commission and the EU IPO. The first one is the position paper, which was quite general and dated of September 6, 2007. The second one is the preparedness note to holders and applicants of EU trademarks and community designs, which was issued by the European Commission on December 1st, 2017. After, as a complement of such notice, the EUIPO issued a frequently asked questions and answers on the impact of the Brexit for EU trademarks and designs on January 18, 2018. And then I will just mention the most recent developments, which were the draft withdrawal agreement of February 28, 2018, and then a most recent version of this agreement highlighting the progress made, a color version, which was published on 16-19 of March 2018, and this will be further explained by Tanya after. Finally, I just wanted to mention, I will not comment, but there were 2 new notices issued on June 4, 2018 in the field of customs and enforcement of intellectual property rights, and also in the field of customs and external trade. So let's start. So we had the referendum, so time was running and something had to be done. So Brexit and users associations. Since the Brexit referendum, all the users associations started considering all the potential effects that the Brexit could have in connection with IP rights. By the end of 2016, ECTA sent a letter to the European Commission proposing assistance in connection with the consequences of the Brexit for IP rights in the negotiations with the UK government. The European Commission invited a number of associations, which were led by ECTA, to a meeting which was held in Brussels on June 13, 2017. The meeting was attended by AIM, APRA, Business Europe, SITMA, ECTA, INTA, Marx, and Union. The agenda of the meeting was quite broad. There were a number of issues relating to the EU trademark systems, issues related to the community design, and then a number of common issues. Since that moment, many different associations started drafting individual position papers on Brexit. But in parallel, we tried to work together and to issue a common document which could be less detailed than the others, but including the points in which there was an agreement between all these associations. And this agreement was sent to the Commission on March 23, 2018. Something in which all of us agreed was that the negotiations on IP issues concerning to the exit of the UK from the EU should be guided by the principles of minimum disruption, minimum cost, and maximum retention of rights. So there were a number of points in this agreement, and concerning to the existing rights, so EU trademark registrations and community design registrations, they should be automatically entered onto the UK trademark register with the same scope of protection, registration date, and where applicable, priority and seniority. Concerning to pending applications, well, that was more complicated, but we had 2 possibilities. Either the EUIPO could continue to examine the marks until the registration, or the UK part could be examined by the UK IPO separately. Whatever solution was adopted, that it was clear that it would be without the need for the applicant to take any step or to make any payment. If finally it was decided that the examination shall be further examined by the EU IPO, a kind of entry should be made onto the UK register so that any third party could be aware that a suitable right could potentially exist after as a separate UK right. A special case concerned the unregistered designs because the national UK design law already provides for a UK unregistered design right, but it differs from the unregistered community design. In fact, the UK unregistered design only protects 3-dimensional designs. Further, since it is a kind of copyright, it requires originality, whereas the unregistered community design must be novel and have individual character over the prior designs only. And another difference is that the UK system foresees a complex legitimating criteria, which in some cases mean that the designs created by non-EU designers will not qualify for protection. So in view of this difference, after the Brexit, the UK unregistered design is not suitable to replace the unregistered community design, and lots of non-registered design would not have protection whatsoever in the UK and in the EU. And under the current EU law, also designs which are made available to the public outside the EU will lose any unregistered design protection. And then when the UK will leave the EU, this will mean that any new design first displayed within the UK would not obtain any unregistered community design protection in the EU. So the proposed solution could be that the UK expand the scope of its unregistered design protection by creating a new UK right which would be equivalent to the unregistered community design. So this way, the same protection could be allowed to the designs in the UK post-Brexit that the one they currently receive under the unregistered community designs. And in connection with existing unregistered community designs at the Brexit date, they should still be protected with an equivalent protection in the UK for the remaining duration of the unregistered community design. The use is something very important and also very controversial. So it was agreed that after the Brexit, any UK registration originating from an EU trademark registration could be, of course, subject to the use requirements under the UK trademark law. But there could be an exception. For a period of 5 years, as from the date of the actual exit, any genuine use made of an EU trademark that before that date would have been considered genuine use of the EU trademark by the EU IPO should also be considered to be genuine use of the resulting UK trademark, even if such use would have not been deemed sufficient for maintaining an equivalent UK registration. Likewise, any genuine use, on the other hand, made in the UK of a EU trademark within the 5 years before the actual exit date should be considered genuine use in the EU of a EU trademark, and this even if the decision of such use is given post-Brexit. In connection with exhaustion of rights, it is clear that the exhaustion may be treated differently in the EU 27 and in the UK after the Brexit. The EU will continue with the regional exhaustion, while the UK has to contemplate other possibilities, such as national exhaustion. So the proposal would be that the EU 27 and the UK should agree specifically that the rules relating to the exhaustion of rights should apply to goods moving between the EU and the UK, notwithstanding that there may not be the general principle of free movement of goods for custom tariffs. In connection with enforcement, also it was proposed that in the interest of the IP rights of the holders in the EU 27 and the EU and the UK, the EU 27 and the UK should continue to have a common custom system, which would effectively counter the trade in counterfeit and pirate goods. Also, the measures for enforcement by custom authorities in the EU 27 and the UK should remain the same, and the EU legislation in this respect should continue to be applied. In connection with representation, as you may imagine, we were a number of different associations with different users, and in the joint statement it will say that nothing could be said in this respect, although we are aware that issues of representation will arise and that each of the different associations could address individual papers on this subject. So now we are going to the official documents that have been issued by the European Commission and the EU IPO in connection with the Brexit. The first one was a very general paper of September 6, 2017. I'm not going to go into detail of all the points, but basically it was maintenance of rights and no administrative burden for the owners and no fees to be paid. Everything which was protected would continue to be protected. So But then we had a little thunderstorm on December 1st, 2017, because the Commission published the preparedness note in the absence of an agreement. What would happen in the case of hard Brexit? So the consequences were quite clear. The registered EU unitary rights, so EU trademarks and community designs, will no longer have any effect in the UK. The pending applications, the same, no longer effect in the UK. International registrations for designs or for international trademarks would have no longer effect in the UK. And in respect of the representation, all natural and legal persons being domiciled or having a seat in the UK will have to be represented before the IUIPO for all the actions with the exception of applications. In complement to that, the IUIPO issued in its website on January 18, 2018, a complementary document on frequently asked questions and answers in a number of issues. But then on February 28, 2018, we saw a little bit of sunshine with the Commission draft withdrawal agreement. We still have some clouds and it's not agreed, but we saw some optimism in the air. So Tania will deal with the draft withdrawal agreement, which is covered, with the IP issues are covered in Articles 50 to 57 of the draft. So I will not comment on that. And now I just briefly expose ECTA position on the draft withdrawal agreement. Firstly, ECTA notes with satisfaction that the general principles of minimum disruption, minimum cost, and maximum retainers of rights have been basically reflected in the draft withdrawal agreement. Concerning to geographical indications, the draft withdrawal agreement provides an equivalent protection in the UK's for GIs, which were protected on the last date of the transitional period. The post-Brexit protection of this right shall be granted under UK law, but the level of protection shall be the same as the level of protection that was provided by the EU instruments. Concerning to cancellation actions...
Would you please speak to the microphone?
Sorry. So, concerning to the cancellation actions against GI pending at the last date of the transitional period, they will affect the validity of the respective post-Brexit UK GIs. And concerning to the pending applications, a right should be provided to the EU GI applicants to be able to extend their protection to have an equivalent UK GI application so that they will not have to refile a new application. This extension is necessary to safeguard the originary filing date because in GIs there is no priority, so it is necessary to keep the date. And also because the examination of GI applications take a significant time. Concerning to the registered rights that were registered at the Brexit time, an equivalent right will be created in the UK, a comparable right. So the filing, priority, and seniority dates and claims will be preserved, and the renewal dates will be the same. ECTA notes concerning to seniority that it is very important that UK rights, which have been allowed to lapse, will be capable of resurrection in order to seniority claims to be preserved. And this is important for IP owners as the registration numbers are reflected into the UK rights, possibly with a prefix. Of course, ECTA understands that this matter should, of course, finally be decided by the UK authorities. Something that is clear is that there will be a creation of a comparable UK right, and that is without cost. It is stated in the withdrawal agreement. However, in the most recent version of the withdrawal agreement, which shows the points on which there is an agreement with the UK, ECTA noticed that the UK has not yet agreed to that. I mean, not agreed that there will be no cost and no administrative step to be taken. We consider that it could not be practical to establish that an application proceeding should be taken, considering that there are more than 1 million registered European Union trademarks. Concerning to the reputation, ECTA notes with satisfaction that a comparable UK right will be able to benefit from the reputation that was acquired through use of the parent EU trademark in the EU 27 before the end of the transitional period. Nevertheless, thereafter, of course, the reputation will depend on the use of that particular right in the UK. And finally, as concerns the representation issue, this will depend on the type of relationship that will be finally agreed between the EU 27 and the UK. So ECTA cannot take at this stage any position on this issue. Thank you very much.
Thank you, Christina, for going through these various documents. Now we will have the UK view. Tanya Clark is partner of Withers and Rogers, and Tanya is a qualified chartered trademark attorney and also a barrister. But last and not least, she was recently elected as president of SITMA, so congratulations to you as well. So I invite you to take the floor and look at the withdrawal agreement from a UK point of view. Thank you.
Thank you very much, and good afternoon. Can everyone hear me at the back? Good. So thank you for the introduction and for inviting me here this afternoon. Ladies and gentlemen, I'm going to give you the UK point of view. I'm going to cover just the background, which some of it has already been covered by Christina, so we can skip over a lot of that. Where are we now and where are we going? So there's a timeline set up there. Probably the most relevant date is the first one, because as Max pointed out, it was when we were in Dubrovnik at ECTA that it all happened, that fateful day. So it's engraved on our memory banks, unfortunately. Then Article 50 was triggered by Theresa May, our Prime Minister, on the 29th of March 2017, which started the clock ticking. Then, as Christina mentioned, we had the EU withdrawal bill published and Q&A published as well by the EU IPO, which in some ways was quite good because it galvanised us all to actually do something about it, because it basically set out what was going to happen if nothing was agreed insofar as trademarks and designs were concerned, EU trademarks and registered community designs going forward. And then, as Christina said, the most important thing, and one I'm going to talk to you about, is the withdrawal bill. It was published initially by the European Commission without any notes, and then the UK put lots of colours all over it. I'm going to go through the colours a bit later on. Basically, it's green, yellow, and white, and it's quite significant what they all mean. The agreement sets out the terms on which the UK and EU negotiators have reached a settlement regarding the transition period, which includes a right for the UK to sign and ratify, but not to implement any international trade agreements during the transition period. It also looks at Ireland, citizens' rights, financial settlement, very important, and the extended protection of IP rights after the withdrawal date. It doesn't say anything about rights of representation, but that's another matter. And as Christina mentioned, following the release of the draft withdrawal agreement, there was a joint position paper which was published. So the transition period, the only thing I want to mention, because you know the dates now, they're all engraved. So from the 30th of March 2019, i.e. the day after we exit, until the 31st of December 2020. That's the operative period. The only thing I want to mention is it's in green, and we'll find out how important green is going forward. I've also put in block capital letters, not guaranteed. Why? Well, because it's just a draft, so it isn't guaranteed, unfortunately. But the important thing is that it means that EU law will continue to apply. Everything will remain as it is during that period. So we've got a status quo, and that again is in green, but not guaranteed. What about Ireland? The biggest problem going, and nothing's going to be agreed until Ireland has been resolved. Insofar as Ireland is concerned, it's a kind of backstop solution. A backstop solution basically means that Northern Ireland, which obviously is part of the UK, will remain in full alignment with the EU's single market and customs. It's basically a commitment to a soft border, i.e. no hard border, between Ireland and Northern Ireland. And it would mean that there'd be complete alignment between the south and the north on customs, VAT, energy, regulations for the protection of the environment, laws governing agriculture, fisheries. And more importantly, Northern Ireland would have to adhere to EU rules on state aid and be under the jurisdiction of the European Court of Justice. So, quite important really, and that was in yellow. Just remember that. But Donald Tusk said point blank that until Ireland has been resolved, nothing is agreed, not even the transition period. So we need to get that resolved once and for all. And that's what's taking up all our UK government's time at the moment. Now, I want to go on about this green, yellow, white and explain it all to you. Green is good. It means it's been agreed at negotiators' level and only going to be subject to technical legal revisions. Yellow, not so good, because it's agreed on policy, but there may be drafting changes or clarifications. White is really not very good at all, because it basically has been drafted by the EU and there's been no agreement, so ongoing discussions. So, as Christina said, Articles 50 to 57 are the most important, and insofar as EU trademark registrations, registered community designs, you'll automatically have, without any form of re-examination, the equivalent. And it does say, at no cost, but the at no cost bit is in white. This bit is in green. So you're definitely going to get your equivalent registered rights in the UK, but we're not sure you have to pay for them. Hopefully not. So all this double filing that everyone's been doing or recommending probably isn't necessary. Well, hopefully it's not going to be necessary, subject to this agreement coming into force. And what about international registrations? Well, international registrations designating the EU, whether you're talking about Madrid or Hague, you should get the equivalent, but obviously it depends on what happens at WIPO. Insofar as Hague is concerned, the international design system, we joined on the 13th of June. We've just got it through, thankfully. So GIs, Christina mentioned, obviously, so that's in white, though. Plant varieties is in green. So the holder of a community plant variety right granted before the end of the transitional period will become the holder of a comparable registered right. And the new UK plant variety right will retain the same term of protection as the corresponding community right. Same filing, same priority dates. The term of protection, as Christina mentioned, is 3 years for registered community design, unregistered design rights. And basically, that will be ongoing in the sense the UK government will recognise it for the full 3-year term, which is good. But it doesn't actually say anything about the mechanics by which this is going to happen. So that's up for grabs. The differences between the two, Christina mentioned, the term is quite different. As Christina said, UK UDRs, unregistered design rights, are not nearly as extensive because they only cover 3D. They are a lot longer, between 10 and 15 years. But in an ideal world, we'll persuade the UK government, amongst other things, to bring in some new legislation to extend our UK unregistered design right protection to cover everything protected by unregistered community designs. But unfortunately, they've got their hands a bit full at the moment, so I don't think it's high on their agenda. But at least it means that for the remaining 3-year period, you'll still have those rights within the UK. The qualification period is different. As Christina was saying, it's quite different in the UK. We have a system of qualifying person. It's actually UK/EU, not EEA, and does include a few other countries like New Zealand and Hong Kong. So we do have a slightly more complex system of being a qualified person or non-qualified person pursuant to employment or commission. and a design first disclosed by the qualified person. The test of infringement are also a bit different because you've got this test under unregistered community designs for copied designs which do not create a different overall impression on the informed user, taking into account design freedom, as opposed to copying the design so as to produce articles exactly or substantially to that design. So going back to the registered trademarks and designs, they are going to be replicated, and as I said, that's in green, so that's good. So far as a correspondence address, a UK correspondence address is not required, although it does say for the first renewal, not required thereafter. Now that's in white, so it's kind of up for grabs. We're not sure what's going to happen on that one. I suppose you can appreciate how that is going to be a little bit contested. The pending applications is probably the one which has been exercising our minds the most. The pending applications, any EU trademark application, or for designs as well, you'll have 9 months within which to file a UK trademark application or a design application, and obviously you'll maintain the same dates. The problem with this 9 months is that obviously it creates a lot of uncertainty. Small and medium-sized businesses are going to be potentially missing the deadline. Also, insofar as EU designations are concerned, we're still waiting, although we've been assured in private it is going to happen, to confirm that they will treat the UK as a successor state under Rule 39 of the Madrid Agreement. If they do, then undoubtedly the WIPO will write to all holders of EU designations to inquire whether they wish the international registration to have continued effect in the UK. If they don't recognise the UK as a successor state, then it's going to be a lot more problematic, and potentially you'd have to refile. But I can't imagine we'll go down that route. And as I said, we're part of the Hague system, so the same will happen with designs. So, as I said, pending applications is the one which is probably the one troubling SITMA the most. We wrote on the 30th of May to the UK IPO, and that letter was endorsed by IP Federation and FICPI UK, outlining our concerns. We referred obviously to the increased costs to businesses, increased complexity, the risk regarding the 9-month deadline being missed, and the opportunity for fraudsters to abuse the system. We've only just, as I speak, had a response back, but it's slightly anodyne. It doesn't really say much, so unfortunately there's not much to say on that. We are considering sending the same letter, or possibly slightly expanded, to the EU Commission with the endorsement of other associations, but that has not yet happened. So insofar as invalidity revocation for non-use, Christina mentioned that that's not going to be an issue in the sense it's going to be recognised. Any use prior to the new UKTM coming into being will be recognised. And insofar as pending cancellation actions, they will impact on the new UK trademark that you're going to obtain. Except, and this is probably quite obvious, except in circumstances under which the grounds for cancellation are not enforceable in the UK. For example, if the application was based on an earlier national right, which is not a UK right, wouldn't have any effect in the UK, then it's not going to impact. Now, that does mean that the validity of these new rights may therefore be in question for some time, until the results of the pending EU proceedings are finalised. And who actually decides whether the grounds for invalidity or revocation apply to the UK, whether the UK will be bound by these EU decisions, it's all a lot to be fleshed out, to be honest. But that bit is in green, so that's good. As Christina mentioned about reputation, that will also be recognised. So that any reputation acquired at the date of the end of the transitional period will still be transferred to the UK comparable right. But the duration and basis for reputation is unclear. We're hoping that basically when there's the final agreement, it'll flesh out a lot of this and put more detail on it. Exhaustion has been mentioned. So all I would say is that care should be taken to identify if goods have been put first on the market in the UK or EU 27 before or after the end of a transitional period. It's going to be difficult for those in the supply chain unless stocks have been run through. So maybe bear that in mind when you're advising your clients. Insofar as judicial procedures are concerned, all those proceedings which have commenced before the end of a transition period will be completed in line with the relevant applicable EU law. And Article 87 stipulates that those qualified in the UK and involved in CJEU proceedings that commence before the end of the transition period, 31st December 2020, or any enforcement procedure that involves the UK may continue to represent or assist the Member State or the UK for the duration of those proceedings. And similarly, it makes clear that those qualified in the UK and involved in CJEU proceedings or any enforcement procedures can also represent, again, all of those in ongoing proceedings. There'll be no break in practicing or not be able to actually represent their clients. So that's good news. So there are a lot of question marks. There's no reference to forms. There is reference to fees, as in being no fees, but it's in white. We're obviously having, as I said before, hoping to have the UK equivalent of an unregistered community design exhaustion. That's up for grabs. Ongoing protection of DIs and ongoing enforcement and jurisdiction issues. SITMAR is going to obviously continue to work with the UK government, with the UK IPO on all of these, and has actually published a number of papers. It published a paper in July 2017, which obviously looked at rights of representation, and how important it was for the profession to be able to maintain its rights, not only before the EU IPO, but before the European General Court, Court of Justice of the European Union. And we, obviously in an ideal world, we would have liked to remain part of the EU system with such that EU TMs and RCDs would extend to the UK, although we appreciated it was unlikely. So we did mention the fact that as a kind of second option, that they'd all be transferred onto the UK register, which is exactly what's proposed to be happening, so that's good. So the second paper which I want to refer to is the business case report, which was produced at the beginning of this year. It sets out the economic impact of losing rights of representation, highlighting the cost to UK business. It sets out lots of facts and figures. For example, the impact that exiting the EU could have on UK businesses with IP interests in the EU, which is an industry worth an estimated £650 billion. Also, according to new research, UK chartered trademark attorneys handle nearly 25% of all EU trademarks, making them the largest representative body in the EU. Second is Germany. But 25% is even greater than Spain and Italy combined. So we're calling on the government to preserve our rights, and at the moment it's unfortunately the case that the UK government has far more concerns in relation to Ireland, so I don't anticipate anything being resolved too soon, and probably not this side of the summer. But thank you very much.
Tanya, thank you for a very clear expose of the withdrawal agreement and the UK stand, at least on some issues. Now, ladies and gentlemen, we are moving on to the corporate point of view. Debbie has graduated from the King's College in London, and she has been working with the trademark team of Procter & Gamble in France for 28 years. So she has a lot of experience in this field. Debbie, I invite you to take the floor, please.
Thank you, Max. Okay. Do I have the presentation? First of all, I'd just like to apologise if you can't understand me. I don't always speak like this, but I have a huge cold. Okay. So I'm going to cover some of the topics that we've already discussed, maybe from a corporate point of view or from my own point of view. First of all, I'm going to talk a little bit about myself. And I'd like to ask you, how many of you exited the UK to come to this conference this week? 1, 2, well, a few hands, okay. Well, I exited, I did my own inverse Brexit of the UK 28 years ago, which explains why I have a very British accent. And I've been working most of that time with P&G in France. My work involves a lot of the non-legal work, which then covers trademark office practices, countries that split, reinstatements, and all of this, just to make sure that everybody has access to the right information and that our rights are protected. So I'm going to tell you, so that's a little bit about me, and I'd like to tell you just a little bit about P&G. So P&G was founded over 180 years ago, with an initial investment of about $7,000. A handshake between two men, a candle maker and a soap maker. These two men, William Proctor and James Gamble, they had one thing in common. They married two sisters, Olivia and Elizabeth Norris. And the banking crisis of 1837 arrived, and their father-in-law suggested that they would better weather the storm if they combined their businesses into one company. And so that small investment and enduring handshake, they followed in their father-in-law's advice, and this laid the foundation for one of the largest consumer product companies in the world. And maybe you recognize some of these brands. Is there anyone that doesn't recognize one of those brands? Okay, that's good. Okay, so we're going to have a little bit of a test here, because I did notice that some of you were nodding off a little bit. So P&G's global trademark statistics, just to give you some idea. I've included international extensions in this because they are cause for some work. So does anybody have any idea how many registered trademarks P&G owns? 50? 50,000 here, another guess? 20, including IR extensions? Oh, well, maybe at one point. We're actually down to 173,000. Pending applications. Any guesses? 10,000? No, then you're going a bit far this time. We have sold quite a few things off recently. We're down to 4,700. Either that, or we just get them through very quickly. And we have pending conflicts around the globe. How many do you think we have of those? 1,000? 500? Nearly. 2,800. And then we get into license agreements, coexistence agreements. Any ideas? Active ones. 5,000? Almost. 9,300. So, as far as the EU TMs go, it all began in 1996. P&G actually filed 226 EU TMs on the 1st of April 1996. 162 of those claimed seniority. That's more than 71%. There are an average of 11 claims per application. It was a lot of work. I remember there were a lot of listings being drawn up. But I was very lucky because I sort of missed the end of that, because 22 years ago I had my own personal project. So what was I doing in 1996 and today? Well, my own personal project now looks like this. But what do P&G and the IPOs, in particular the EU IPO, look like today, 22 years later? Well, we have over 2,000 registered EUTMs. So that's over 2,000 trademarks that are going to get taken back into the UK. We have over 3,000 RCDs. We currently have 600, nearly 700 registered or active UK marks. Out of those, we only now have 15 which were used as seniority claims. In the very beginning, when the then OHIM was first getting all these seniority claims, it was very difficult to handle, so P&G actually renewed and kept a lot of their UK national marks, which were used as seniorities. But now that the EU IPO have all of this under very good order, we only have 15 left that are seniorities. So we have 52 pending EUTMs, and we have 26 actions pending at the office. So what was our first reaction to the Brexit announcement? What did we have to think about in our filing strategies for Europe and the UK? Well, so we asked ourselves a certain number of questions. Is the project relevant to the UK? Are we planning on using in the UK, only in the UK, or not at all? I mean, how important is our trademark from a legal perspective, from a business perspective? And what will the UK business be? I mean, do we expect this to expand and be the next Pampers Baby Dry? So, and then strategic value. This gives us 5 years to confirm how we want to expand the brand. Or maybe we don't want to file in the UK at all. How will competitors react to an application if we file at the UK, at the EU? It's not obvious where we want to use the mark. If we're filing in the UK, it's becoming more obvious we want to use the mark in the UK. Is that the case or not? Is there a strategic value in finding the mark beyond the general uncertainties linked to Brexit? Would a UK application be part of a clearance strategy? Do we want to keep a low-profile clearance in the UK? And most of all, one of the biggest questions that corporations are asking themselves every day, what does my budget look like? It's our favorite subject at the moment. So I'm going to see a little bit how awake you are, and if you've been paying attention, and at the same time, maybe give you a few comments. We're going to do a little crossword. Okay, it doesn't look like a typical crossword because doing a crossword in PowerPoint is not that easy. Not that it's me that did it, but so in actual fact, the white spaces are what you should be looking at. So I'm going to ask you a few questions, and we'll see how you do. So one across, you'll notice there are 3 spaces. So one across is a place where pending actions might still be awaiting decisions at the moment of Brexit or the end of the transition period. Any ideas? It's an abbreviation. Yes, Board of Appeals, BOA. That's right. So what are we going to do? I mean, what do we want with that? Do we want these decisions to then just suddenly be taken up and split and the UK part go back to the UK? Is that really the best solution? I don't think it is for trademark owners. I think that the ideal situation would be to keep these with those who are already handling the matter, and we wait till a decision, and then that decision would count also for the UK. Oh, sorry, I've given you the answer to that one. 3A, costs involved in establishing a new UK trademark right from the EUTM. Well, we want it to be free. It may be in white, but we really want it to be free. That would be the ideal situation. 3B, which agreement did the UK adhere to this week? Yeah, easy one. There you go. So that registered designs will have the same protection as currently under the RCDs. How many did I say we had registered designs? Who was listening? Perfect, 3,376. Great. 5 across. What we would like to keep with the new UK trademark right? Priority. Well, that's one of them. There you go. Yes. So that's definitely something we want to keep, of course. 7 across. How have trademark owners and users associations expressed themselves on these points? They have written some papers, yes, they did a joint position paper. And I'd just like to thank the users associations for defending the trademark owners' desires, wishes, and requests. Thank you. So, 9 across. What would be, where would there need to be an easy mechanism? Something which could be complicated and tiresome, particularly considering we have over 2,000 EUTMs. What could be something we want to have done very easily? It's establishing something. I may have heard it. An address, the address for service at the UK IPO. Obviously, we don't want to have to fill out, 2,000 forms or sign powers of attorney. We want it to be very simple. And I'm not really sure that we agree that we want representation to be at first renewal. What happens if we need to be notified of something, a cancellation action or something like this? In a big company like ours, if somebody writes to the Procter & Gamble company in Cincinnati, it will probably take 3 years before that gets back to the person who should be handling it. So I think we definitely want to make sure that our representation is recorded from the start. Okay, so we're on number 13. Why might we end up with 2 identical UK rights? No? It's the line 13 on the bottom. I'm not quite sure how many. Seniority, as I said, we have 15 trademarks that are worth of seniority and they cover the exact same goods as the EUTM. So what is going to happen when those trademarks come back? Does that mean we're going to have double trademarks on the register? Can we merge them? Will there be something put into place? Okay. So now we're going to start going down. So number 5 down, easy one. Is everybody awake? Topic of today and the name given to the UK's leaving of the EU. Don't know if anybody did not get that one. So obviously we don't want a hard Brexit. It would be great if we could have a soft Brexit and the UK comes to agreements with the EU on certain aspects. The combination of both, the creative Brexit, would be something similar to the EU and Norway, Switzerland. That could possibly be acceptable too. But I think that we need to have some sort of agreement set up. 12 down. What is necessary when filing an application at the UK IPO? It's another abbreviation. Yes, ITU. A bona fide intention to use. Apparently, all the registered EUTMs are going to be brought across, are going to be considered to have this. That's what I've heard. Okay, 10 down. How would we like the process of transformation of an EUTM or an RCD to be into the UK right? That was easy, right? Yeah, no formalities. The data, I'm sure it can be easily transferred from TMView onto the UK register. So that's going to be something which I hope remains very green. One down. Okay, here we go. What would we like the EU IPO to complete with respect to pending applications? Yeah. Okay, maybe this is a dream for trademark owners, but wouldn't it be so much easier? I think this whole thing of 9 months is not really what we want to have. especially maybe the chances of registering in the UK are not quite as hopeful as registering at the EUTM, or we don't want to have two parallel processes going on at the same time. So why not let the EU IPO complete the registration and then transfer the marks? I've converted quite a few marks in the past, and I must admit that when you convert them into UK national marks, you're not sure that after examination they're going to get accepted. Okay, something which is very important, 13 down, something very important for trademark owners is legal. Great. I can see some of you are still awake. So, yeah, we've covered this again, simple transformation, no loss of rights. 6 down, what needs to be considered with respect to license agreements and coexistence agreements? And you've got 2 letters there, so. Scope. So P&G currently has at least 12 active license agreements that state a European Union in their coverage, and approximately 230 coexistence agreements. This doesn't mean they cover necessarily European EU countries, but they state that this agreement covers the European Union. So if they cover the European Union when they were executed, then they should cover the UK when it leaves, in my opinion. Maybe parties will feel happier if they renegotiate or amend their agreements, but I would see no reason why that wouldn't be the case. However, for recordals, we have a few license agreements recorded at the EU IPO. So what would we have to do for those now? Would those recordals be carried over, or do we have to go now and re-record those licenses for the UK? Just questions we're asking ourselves. This is getting into the nitty-gritty because we're leaving the experts to do all the hard legal stuff. I'm just worried about how I'm going to manage my portfolio. 9 down. Who is going to require more resources to cope with the arrival of more than 1 million extra trademark registrations? Good luck to them. So apparently they've been recruiting. It's going to be some big, tough thing to integrate 1 million trademarks. The final one, 3 down. With respect to which agreement would we like extensions to the UK to automatically... Excuse me, I'll start again. So with respect to which agreement would we like extensions to the UK automatically brought over if the mark covers the UTMs? Yeah, of course. So, why wouldn't they just create an extension UK at the time of Brexit or the end of the transition period? It can't be that difficult just to add a little extension. Are they really going to ask owners who've got hundreds of international registrations to say, yes, I want this one, I don't want that one? I'm surely they can just do some computer tool and just add them all on. So, you did very well on that. Just a few extra comments on impact on industry. The first general reaction to the announcement of the referendum to leave the EU was catastrophe. Some of the comments published in the media at the time, interest rates in the UK in November 2017, for the first time in a decade, salaries remained stagnant, became the worst performing country in the G7, biggest financial squeeze for families since the 1950s. London, no longer a tech capital. Recruiting may be an issue. Less people from the EU want to look for work in the UK, with the exception of Facebook, who opened a hub in December employing 800 people. Supply chains, automobile industry, aeronautics, they're affected. Relocalization of activities, so changes in relationships with providers and subcontractors. The UK's automotive industry produces an average of 1.6 million cars each year. A total of 77% are exported abroad, of which 58% are sent to EU countries. And the EU awarded the Netherlands the right to host the European Medicines Agency, which up until now was based in London. So, catastrophe, what's the UK going to lose out on? Well, impact on industry, is it really? Not everybody agrees on that. Recent figures show that some companies are not affected. Shell, BP. Brand finance CEO David Hay considers that Brexit is proving to be an opportunity and stimulus for many British brands. It is becoming clear that the UK economy is far more resilient than predicted, and that UK brands are responding well to the challenge posed by Brexit. So is Brexit really that bad? Well, we can only wait and see what upcoming political decisions are made, the future regime of exhaustions of rights, etc. But in any case, I don't know how the UK, excuse me, how the UK is going to fare. But my own personal Brexit went very well, and I'm enjoying life in the EU. Thank you.
Thank you very, very much, Debbie, for an interesting and stimulating talk. All of you sitting here in the audience, be ready for a quiz if you want to work for Procter & Gamble. So, I will first ask the participants here in the panel if they want to make comments. What about Christina, Tanya?
Yes.
Please, go ahead.
I just wanted to make a comment because Christina mentioned EU customs notices and something's just come out on it. There's been a notice to stakeholders that if you filed an EU customs notice via a UK customs, then it will no longer apply, which is a bit worrying. Obviously, post the end of a transition period, we anticipate that you'll have to take out a UK customs notice anyway, because obviously the EU one won't apply in the UK. But it's a bit concerning that all those which we have filed, obviously via the UK office, won't actually apply within the EU. So you might want to, this might change, because it's just hot off the press, but you might want to review what your clients are doing or what you're doing on your client's behalf in relation to customs notices.
Thank you, Tanya. Now then, I will open up the floor for the audience. We have 10 minutes to go for questions. Please come forward. There is a lady in the middle over there. Please state your name and try to be brief.
Hi everybody, I'm Janine from Malta. My thoughts about Brexit are on the other side, and I'm thinking about what is going to happen with the official language for proceedings, whereas most of the oppositions that we are involved in are all in the English language. The laws that are passed by the EU, we still refer to the English language texts instead of texts in Maltese, etc., etc. So I just wanted to raise that as a little question mark as well. It's totally from the other side of the coin.
Thank you. Do you in the panel want to say something?
This was raised at the outset, whether they would keep the English language, and you're right to be concerned about it. But obviously, don't forget, you've still got Ireland, they speak English there, as well as Malta, Cyprus. So we've been assured several times over that English will remain as one of those languages. Debbie, I don't know if you've got other experience.
No, I would expect the same thing. I mean, English is such an international language nowadays, and Ireland is using English, so there would be no reason to not do it in English. And in actual fact, I think a lot of the meetings at the EU IPO are held in English, so it seems obvious to keep it.
Exactly, because Ireland, EU has an official
Well,
language, Maltese has more
Please use the mic.
Sorry, because that's the point. The Irish had officially chosen Gaelic as the language, and Maltese is Malta's official language as well. And so, kind of officially, there isn't one. But I agree with you. It is the language in which all the meetings are held. So it would be nonsensical to lose it.
Thank you. We have a question here at the very front. Please.
It's an answer to that question. English will stay an official language of the EU. In article, I think it's 237 or somewhere around that, it says the official language can only be changed anonymously. And that will not happen, that all of the 27 remaining member states anonymously say no English anymore. So we are safe with that, I guess.
All right, thank you. Any other questions? Please go ahead. State your name.
I'm Christian from Bayer in Germany. I wonder whether the UK government has made up its mind already on the exhaustion system which they want to adopt after Brexit. Sorry. I recall 20 years ago when there was a big discussion whether the EU should move to the international exhaustion. It was especially the UK and companies like Tesco and so they preferred to change to the international exhaustion.
Thank you. Tanya, please.
I have attended meetings with the UK IPO where they've been researching the different possible types of exhaustion, but no decision has been made. So it's still under review, but they are looking at every possible.
Thank you. You want to continue?
Just one comment.
Yes,
because
please.
it may have an impact also on the question how to deal with Northern Ireland, because if the EU remains with the EU-wide exhaustion and the UK would then move to the international exhaustion, then we would have a little problem.
Yeah, a very big problem with Ireland, yes.
Okay. We have time for 2 more questions. 2 more. Somebody feeling an urge to say something? Apparently not. That's amazing. So, ladies and gentlemen, there's one. There's one. Thank you.
Hello, Tanya. You might know the answer to it. It's Karen Birchall here. The basis for a Madrid application, if it's an EU basis, are we just assuming that the UK gets separated out and then the international's done from that? Has it been discussed?
No, it hasn't been. The Madrid, as I said, we have had reassurances from WIPO that there'll be no issues, it will just be split out going forward, but no actual decision has been made. Although within the withdrawal agreement it does provide for the fact that EU designations, you will get your equivalent right, but obviously it's subject to, we're not sure how or in what state it's going to be, and whether the EU designation is still pending, what will happen then. None of that has been fleshed out.
Okay, ladies and gentlemen, we'll stop here and I extend my warm thanks to the panelists. Very good. Thank you.